In the Idaho4 case, the Kohberger prosecution, the attorneys are at each other's throats again, and it's all over the non-dissemination order.
So, what is okay to say, and what's not okay to say? This gag order has got everyone confused. What is it okay for people to talk about? I'm Lainey Law.
And I'm attorney Andrew Myers, and I have the answers.
Nothing. What are the answers?
Well, again, we need, as in all the other episodes, we like to look forward, and you have to keep your eye on the ball here. The eye on the ball is, there's a prosecution against Brian Kohberger. Is he guilty or is he not guilty? And we've all along said that we respect the right to a presumption of innocence. Now, in order to get there, there has to be a fair trial. And Taylor, his attorney, had started to do a survey of prospective jurors, not the jury, but the veneer. And in a previous episode, we talked about the difference between the actual jury that's seated in the case and the veneer, which is all the potential jurors that could sit. So the prosecutor, Bill Thompson, found out about this. He called the police and they investigated. And now there have been a series of hearings as we sit here today recording this episode. There have been 2 hearings in which the parties and Taylor's expert have literally been at each other's throat, and the expert saying he was angry. So what's all this about? Well, first of all, there were calls that were made to people in Latah County, Idaho, which, of course, is where the crimes occurred and where the trial will be taking place. So according to Ann Taylor and her expert, a fellow by the name of Brian Adelberg, who we will hear from later, they were calling people to do a survey. Bear in mind, this survey of this type has been done a number of other times in other jurisdictions. And as Ann Taylor explained to the court, the defense was not disclosing information. The defense was asking prospective jurors in the county of Latah as to what information they are aware of that was previously disclosed in the press. So that's a pretty easy distinction to make. Is that confusing at all?
Not at all. I mean, we're here talking about everything that's been talked about now. It's not that they're talking about anything that hasn't been disclosed already. Anything that they're asking these people about are things that's already out there. It doesn't seem bad at all.
Right. So again, let's keep our eye on the ball. There's 2 different types of information that we're grappling with here today. One type of information is all this stuff that's been sealed. We showed the docket in our previous episode. This is sealed. That's redacted. That's going to be kept secret. We can't talk about that, all the way to the beginning. And there's this non-dissemination order that says you can't, if you're an attorney or another class of person affected by that order, you can't discuss any of that secret information. Then the other category of information is stuff that is out there in the press. It's been, published TV, radio, newspapers, and all the rest. And so now that we've clarified that, we move on to the actual survey by Mr. Edelman. And as I pointed out, the survey instrument topics of focus and the questions were construed after reading more than 269 articles that reference the murders in the Moscow Pullman Daily News, the Idaho Argonaut, and the Spokesman Review. So just to be really clear, there's this sort of information over here that's private and secret and redacted and all the rest, and you're not allowed to talk about it. Then there's the stuff the survey focused in on. It focused in on what's been out there in the press. So
I think the fact, too, that it references like the Moscow and Pullman Daily News and the Idaho Argonaut, I think it's very relevant to what people in the area would have had. I'm sure, it talks about 269 articles. I'm sure there's some that aren't location specific, but I would believe that in a situation like this, it's similar as to like the kind of mail that you would get in your mailbox or pick up at a grocery store, where it's stuff that people in the neighborhood in the area might have seen just walking by in their daily life. It's nothing crazy.
Right. So this stuff is out there. Now, it's true. Not everybody reads the newspaper. And there was an argument that was made that, why talk about this stuff and quote unquote taint jurors if they don't read the newspaper? Well, again, it's all public information and it's all out there. So this bad secret stuff over here was not the topic of the survey. The stuff that's been in the 3 newspapers and the 269 plus articles, that was in the survey. So what's the problem? Well, Idaho County Prosecutor Bill Thompson argued the survey violated the gag order, which prohibits attorneys from talking about the case to the public and could taint potential jurors. What? Does that make any sense? So in a hearing that was held on April 10th, the expert, Mr. Edelman, wanted to show a PowerPoint presentation that explained what had been done in this case. And Mr. Thompson got up repeatedly and objected to the showing of this PowerPoint. He objected vociferously and very strongly to not show the PowerPoint. Well, after 25 minutes of going back and forth for 25 minutes, they finally showed the PowerPoint. And I don't know, maybe about a dozen slides in, it was revealed that at one point in the presentation, which Thompson, as we just pointed out, objected to being used, there was a video of Thompson back in December 2022 telling the media that the probable cause documents would be coming out soon and that media should share the details with their viewers. So here he is saying, let's not show the PowerPoint, but once we got into the PowerPoint, there he was. And not that that was a violation, but why would he not want to show the PowerPoint? Mm-hmm. So we gotta get a little bit of background here. And for background, as has been pointed out previously, surveys like this have been done in other jurisdictions. Let's take a look. Interestingly, in part of the PowerPoint that the expert did show, here's one of the slides. He pointed out that the same method has been used in hundreds of change of venue surveys going back more than 45 years, including the Oklahoma City bombing, the Boston Marathon, George Floyd case, the Parkland shooting, the Pittsburgh synagogue shooting, and in 2 cases in Idaho, the state of Idaho versus Jonathan Renfro and the state of Idaho versus Gilberto Rodriguez. And so in fairness to Mr. Thompson argued in court that, well, he doesn't care about those big cities. He does know Latah County, and he's not concerned with the other times where these surveys have been used. He knows Latah County. Fair argument, but if those types of surveys have been done in all of those other cases in all of those other areas, isn't there some kind of precedential value in recognizing the fact that these studies have been done elsewhere without a huge problem?
I feel like saying like, oh, Latah County, I feel like that's just kind of like a cop out where it's like, yeah, I see it works in all these other different locations, but just using personal experience, like you said, I think you're right where there's established precedents in this situation.
Yeah, so it just seemed like an unseemly argument that was made with a lot of force to it. So then now the question comes up. The reason that the judge brought the attorneys into court was that he felt that the survey violated the non-dissemination order. So now let's take a look at the non-dissemination order, and we have it right here. And here it is. It's been revised a couple of times, but here's the one that's in effect now. It's the revised, amended, non-dissemination order. And it was filed on June 23rd of 2023. And it says that the prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family are in fact prohibited from making extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. This order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following. And then there's a whole list of things that the attorneys and others are, told, don't talk about this. This is a non-dissemination order, so don't talk about any of these things. But wait, there's more. Paragraph 2, attorneys involved in the case and their agents, as outlined in paragraph 1, may make extrajudicial statements, written or oral, concerning the following. So, on the one hand, it says don't talk about this stuff, but guess what? You can talk about this stuff. And then it lists several things: the claim, offense, or defense involved, and except where prohibited by law, the identity of the parties involved. B, again, bear in mind, these are things that the parties may speak about. They may make extrajudicial statements to be information contained in the public record.
But Andrew, isn't the newspaper public record?
Well, I would say so because, I was a reporter for years, and so I might be slightly biased. I will disclose that. But newspapers are generally referred to as the newspaper of record. The New York Times is the newspaper of record for New York. The Los Angeles Times is the newspaper of record for Los Angeles. The Boston Globe is the newspaper of record, arguably, for all of New England. So, I won't go on and hit every city in the country, but, arguably at least, and the parties don't agree on this, but information contained in the public record is stuff that's out there. And so that was the argument that was made by Ann Taylor that, look, we're not going into anything that's not already out there. We're not, quote unquote, tainting any jury pool. If we're tainting anything, it would be the veneer. But in any event, this stuff is out there. So, this is important enough for us to really focus in on. And here it is. The revised amended non-dissemination order says attorneys involved in the case and their agents, as outlined in paragraph 1, may make extrajudicial statements, written or oral, concerning the following. Yet here is what the prosecutor had to say about that.
On the issue of whether information already publicly available isn't included in Your Honor's order, which it clearly is because it doesn't say otherwise, we know that there is no exception in the court's order saying if the information is already publicly known, it's okay to disseminate it again.
Wait a minute. Did I read this correctly? Attorneys involved in the case and their agents, as outlined in paragraph 1, may make extrajudicial statements, written or oral, concerning the following. B, information contained in the public record. Wait a minute. Did I not hear something correctly?
On the issue of whether information already publicly available isn't included in Your Honor's order, which it clearly is because it doesn't say otherwise, we know that there is no exception in the court's order saying if the information is already publicly known, it's okay to disseminate it again.
All right. I don't want to split hairs, but the non-dissemination order says what it says, and, there it is. Again, I don't want to split hairs, but a lot of people refer to this as a gag order. Now, what do you think of when you hear of a gag order? Exactly. Don't you, when you think of a gag order, don't you think of, exactly tying a bind around somebody's mouth and not letting them speak? And so it's some external force saying, no, you can't talk, you're gagged. This really isn't that. And again, I'm not splitting hairs. Follow with me here. This is not a gag order. It's a non-dissemination order. So instead of being something from the outside saying you're gagged, it's something from the inside saying you can't take the stuff that you know about. Remember, I had the bad stuff and the good stuff, the bad stuff and the good stuff. The bad stuff over here would be what, the attorneys already know about, and they're being told not to be gagged, but not to disseminate this stuff from. We're on the inside and we know all this bad stuff and we don't want you to disseminate it to the outside. So when the non-dissemination order says, you can talk about these things, they're over here. They're in this category of the good stuff. So I'd love to hear what you have to say about that. But I think that Ann Taylor has a very good argument that what those words mean are very essential, and they would allow for some of these questions to be asked to not the jury, but to the veneer at this time. So we attorneys only have words. That's all we have. We're not like plumbers and carpenters and electricians that, they're very masterful with their hands. And I admire them all because they have these tools and they know how to use them. All we attorneys and judges have is words. So you got to use them carefully. And this says that you may make extrajudicial statements concerning things that are in the public record. And newspapers are commonly referred to as the newspaper of record. So I think it's a stretch to say that the parties are not allowed to talk about those things. I really do.
Well, the thing is my thought is if they're not allowed to talk about those things, what are they even allowed to talk about? It feels like the only person having any repercussions for saying anything is Ann Taylor at this point, because it feels like everybody else in the case is able to talk as much as they want. But as soon as Ann Taylor starts working with a company that has rapport, now all of a sudden it's an issue.
Yeah, it just, and the other thing is in the hearing, and I'm not going to play the cuts, but it seemed like there was a lot of rancor. It didn't seem to me that we were focusing, or the parties in the hearing were focusing on the issue at hand. It seemed to me that there's a lot of emotion. There's a lot of rancor. At one time, even the expert himself said that he was angry, and Bill Thompson said, "Will you stay angry?" And a court of law is not a place for these things.
Kangaroo court.
And in my opinion only, I don't know why there were two hearings. There was a hearing on April 4th. There was another one on the 10th. In my opinion, the whole thing could have been resolved in one hearing. In the first hearing, the expert, Mr. Eckenberg, was available. He was available on Zoom, which is how we do stuff these days. Post-pandemic, Zoom is good. So he was there. He was ready, willing, and able, but he was shut down, given a whole week to come up with this crazy PowerPoint, which, the prosecutor didn't even get until 5 hours before the hearing. And so, and then the second hearing went on for 2.5 hours. In the interest of full disclosure, I fell asleep. I did rewatch it. I went back. I went back to the beginning and I watched the whole thing. So yes, I do know what I'm talking about. Thank you. I did watch the whole thing. So, it just seems to me that the whole thing could have been wrapped up in the first hearing. There was no need for the second hearing. I think, aren't a lot of people now, a lot of thinking individuals who follow this, questioning, whether the court has just lost control of this, whether the court is just sitting there letting the parties be angry, letting the parties argue, letting the parties get bogged down in this. It's a study that has been done elsewhere. It only called approximately less than 1% of all of the eligible jury veneer in Latah County. So it just seems to me that a lot of intelligent people are questioning, why is this going on and on? Why are they getting bogged down in these details? It's just, to me, it's another example of, for example, the 51 terabytes. Has anyone heard about the 51 terabytes?
Those 51 terabytes, some say they're still combing through those with a fine-tooth comb to this day. I can't imagine what they're going to do about that at all.
Well, the way I look at it is this. The way I look at it is that, I don't even remember how long ago the 51 terabytes were mentioned. Some time ago, because I looked for the slide and I couldn't find it. So it was some time ago. Well, how can the court devote, 2.5 hours of judicial resources to this when it could have been handled in one hearing, when we don't have an action plan on the 51 terabytes. All of these hearings have gone by and we don't hear about it. It's kind of like a sword of Damocles hanging over the whole thing. There's no action plan. The court hasn't the court asked the parties, have you guys met to, maybe categorize or index or, point out what's important in there to help each other go through it? Or hasn't the court asked, is there an action plan? Or should, instead of wasting 2.5 hours on a hearing of this nature where the parties were just, jibber jabbering back and forth and being angry, hasn't the court, devoted some resources to focusing on what's at hand and saying, is there an action plan on the 51 terabytes? Have you hired a skyscraper full of paralegals and attorneys to go through the 51 terabytes? Do we know, what the end game is? Are you going to be done next March, or are you going to be done in March of 2030? Which, by the way, you know what, folks, that's a possibility based on some cases we've talked about in the past. But I digress. I guess what I'm trying to say is if the court has the resources to hold these hearings, multiple hearings, and then not order something to be done. I mean, we've got all these different issues just kind of swirling around, and I just isn't it strange that often the courts correctly tell us, I'm not going to use the word complain, but they point to the fact that, judicial resources are limited. Well, if they're limited, why are they going on and on and on and on and on about some of this stuff?
I don't know. I agree with you where we're spending a lot of time talking about this when there's a lot of actionable things that could be done. And this, like I mentioned before, it just seems like an unnecessary roadblock when, people are able to fight for a half hour on whether or not a slideshow was shown. I think that, you would think that would seem to be like little facets like these, or these are just like, some minor things where it's just like we already discussed, is just like these are things that are already in the newspaper. We're just asking people about things that are already up here. I think that we're spending a lot of time and energy focusing on that stuff when, like you said, is just like, what's the news on the skyscraper full of paralegals? Like, how are we actually going to be moving through this case? Instead of moving through this case, we're just finding every single roadblock we can and then staring at it for multiple days. It's crazy. Waste of time.
You know what it reminds me of? As you pointed out, they wasted almost a half hour, 25 minutes on whether or not to show the PowerPoint, which they ended up showing the PowerPoint, which went on interminably and put me to sleep. Yes, I went back and watched it so I could do this podcast and say, yes, I watched it. But, you know what, arguing over whether or not to show the PowerPoint, you know what it reminded me of? And I'm going to date myself, and I guess that's okay. If you want to get the hook and pull me off, go right ahead. But it reminded me way back in the Vietnam War. The Vietnam War was raging, and they were sending kids home in body bags, and the whole country was falling apart. And so they decided to have peace talks in Paris. And rather than starting the Paris peace talks, do you know what they argued about for weeks? What shape was the table going to be where all these leaders from France and England and NATO and Vietnam, North Vietnam, South Vietnam, China, Russia, what shape was the table going to be?
You're about to make me scream.
And it was just like, anyhow, so some interesting things did come out about this. And it was kind of a sideshow because, as we pointed out before, there was the bad information and there was the good information. And some of the good information that had been in the newspaper, sure enough, wasn't necessarily true. Well, guess what? The prosecution has kind of backed off on some of its claims. You know how sometimes we hear that it is alleged that Brian Kohberger stalked these victims? Mm-hmm. You've heard that, right? Mm-hmm. Brian Kohberger stalked the victims.
We've talked about some of these theories on this channel. For those who aren't familiar, check out some of our past collaborations. Yeah, we've gone through some of these theories.
Guess what? Maybe he didn't stalk them. Maybe he didn't stalk them at all.
False that Mr. Kohberger allegedly stalked one of the victims. That's false. You know that to be false.
Which one?
that Mr. Kohberger allegedly stalked one of the victims.
Yes, I was trying not to say that because.
But you knew that was false.
I did.
Yes. And so you have now, for anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false.
That's false. Yes.
Yes. Okay. Thank you. Thank you.
Okay. All right.
So if in 2.5 hours of a hearing on a Wednesday night prime time or sleeping time, in my case, if any news came out of it, guess what? The prosecution itself is now saying that Brian Kohberger did not stalk the girls or anyone that was involved. So, I mean, that's the breaking news, folks. I don't know, but took a long time to get there. And I'm just wondering, I don't know what else that has been out there is not true. I mean,
and like how you said, what else is out there is that's not true. I'm wondering, do you see this as a little breadcrumb? Because now we have that he potentially seemingly did not stalk these people. So do you think that this is going to bring things more on the rails? Or do you think that this is just a complete distraction from getting to the actual point of all of this?
Well, it's hard to know because, so much has been, like I said, how many times have I said this? There's all that bad information over there. And I think it's starting to leak. It's starting to crumble. And a lot of observers, to this case, over the last year plus questioned the whole thing. We've now had well over a year to question the probable cause affidavit, the timeline. How did these 4, awful, horrible crimes occur in that short 16-minute less window? Do the Moscow area cell towers really ping accurately enough to say that he was, going by that location? Or, some credible people, in a previous episode, we talked about one of the experts who's testified in other trials have said, no, there are not accurate enough cell sources of data in that area to say that he circled around 12 times. Other things that are in the probable cause affidavit that have now had to withstand a lot of scrutiny, include this 2011 to 2013 vehicle. Oops, no, it's a 2015 vehicle, even though the expert at the FBI, whose only job is to know about cars. So there's a lot of stuff that's out there, and you ask a good question. Is it like a ball of tape, and once one little piece starts to come off, the whole thing unravels? I don't know. It's a good question though. What else?
We've mentioned this before. I hope that we see this year that something changes. It feels things are moving, but at the same time, it feels like we're getting stalled by a lot of dumb stuff, in my opinion. Not a professional opinion, but I agree with you. I hope that we see things start to unravel. I hope we see things start to change. I'm curious if we're going to have any major informational breakthroughs within these next few months. I'm curious to see.
I'm doubting it because now they've set back the next hearing on change of venue. That's been pushed back to, as we sit here now, June 27th. The discovery deadlines don't come up until September and January. And where, we've seen the alibi deadline pushed back, and now we've seen the change of venue deadline pushed back. Does anybody really seriously think that those discovery deadlines are going to be adhered to? And we don't even have a trial date at this point. So I don't really know. I did have a prediction, and I've been wrong before, and I never put money on the football games. But I have a prediction, and that is that there's been so much focus on this case that somewhere, somehow, someone is going to leak something this year by the end of 2024 as we sit here recording this. That's my prediction. Having watched news, having been in the news business for a decade and watched news a lot since then, my prediction is that, reporters get kind of cozy to sources. And after a while, things start to break down. And again, a lot of people think that they call it a gag order. And it's, in my view, it's not a gag order. It's a non-dissemination order. You can't tap into this bad stuff. I'm going to have to get a bucket next time so I can have a prop to, distinguish the two types of information. But where I was going with that is someone somewhere who is privy to all of that information, whatever it is, whether it's, social media contacts, or whether it's, whether there was some other DNA somewhere or something, someone that's privy to all that is just going to not be able to take the pressure anymore and leave a document on somebody's bedstand, or leave a document, in a parking garage and say, hey, come over here to a parking garage. I got some documents for you. It's happened before in other cases. And if you're my age group, you know exactly what I'm talking about. So, yeah, I think, I don't think this pressure can sustain. I've said it before. I'll say it again. The gag order has had the opposite effect that it was intended to. It's generated additional interest in the case. It's generated additional public focus on the case. More and more people are coming in to discuss it. I do watch a lot of Facebook. I try not to get kind of bogged down on some of the stuff that just, oh my gosh, the tunnels. No, come on, please spare me. What was the other thing we were talking about before that was kind of like the tunnels? I forget. But, spare me all this stuff that's out there. But where I was going with that was that there's more and more focus. In watching YouTube, there's new channels all the time. There's new channels. There's a new YouTube creator that's out there that's just released 4 new episodes on her take on the whole thing. And she comes right out and she says, I'm new. So here is my take. And it's a breath of fresh air, because we've all gotten so far down into the weeds that she's out there saying, hey, here's how I see it. And she goes all the way back to the beginning and points out that none of it makes any sense. So, anyhow, there's just been so much pressure. And I think I did say this in a previous episode that, a lot of times one of the strategies in a high profile case, nothing this high profile, but in the areas where I practice and live, there've been some cases that hit the newspapers and hit the press, and the editors start, writing their little editorials. This is horrible, and we've got to do something about that. And so the prosecutor and the defense and the courts kind of go along with the idea of delaying it and pushing it back, and wait until the public sentiment dies down a little, then we can slide it through. And I've seen that happen. I've seen that happen in some cases in my area. I could cite them, but unless somebody in the comments really cares about my rant about that. But that's one of the strategies. These high profile cases, you want to bring them down, continue them until the newspaper editor goes on to something else, forgets all about it, and then slide some kind of a deal through. That ain't happening in this case.
You brought up a really big thing where how long is it until some information gets out somehow, like some tech savvy person finds a document and drops them somewhere where, people can see them. And I definitely feel like the chances of that happening are so high when you consider how many people are involved in this case. Like even my thoughts are is like the people in the house when the police arrive there. It's like how many of those people have some type of information and might say something? How many people are working at the school and have access to certain emails or documents that are working in the office? Who's hiring a new paralegal? And, obviously in those situations, there's a lot of precautions, but it's just like there's so many branches of people who are connected to this where it wouldn't be surprising if something just fell through eventually, or even just security things. I mean, how often do you hear about giant companies getting hacked and all of their user information being disclosed? Exactly. So, it's a dam waiting to burst.
And the other thing is another potential source of breaks would be, the University of Idaho has really clamped down, and, the president has really kind of ridden herd over the case. But some of the students are going to be graduating, and some of those students might kind of know a few things about what might have kind of happened. And, you know, the victims in this crime were very well known. They're very popular. It was a party house. I'm not going to say the other thing I always say after that, but it was a party house. So a lot of people knew them. Some of these people are going to start graduating pretty soon, and they won't be under the thumb of the university. And they might start, you know, saying things. I don't know.
I agree with that.
I've talked to a few people on the inside of this case, and I've, you know, promised to hold their confidentiality. So I'm not going to go any further than that. But I have one more thing to say about the gag order.
Uh-oh.
Steve Gonsalves was on another channel 4 days ago. And he and his wife, Christy, were just, you know, understandably wringing their fists about this, you know, and here's a direct quote. "We know the gag doesn't permit the truth. We know it permits rumors and lies and conspiracies. So I still don't understand why you would ever want to hide the truth." Quote, "What court case wants to hide the truth?" Good point.
Very good point.
Good point. So on that note, at this point, Lainey, do you have any closing thoughts?
I agree with our last quote from Steve. I think that transparency would settle a lot of these crazy rabbit holes that people are going through. I think a lot of people watching this want justice to be served and feel very passionately about it. And if the court was just transparent, I think that you would have a lot less of these crazy conspiracy theories.
Oh, absolutely. So we do welcome your comments. Please be polite. Please be respectful, as we always say, whether you're in the grocery store or the big box store. Remember to be kind to people. They don't know, you know, you don't know what they're going through. And I always say, please comment all you want. We love it. If you go down through, you'll see there are people that don't always agree with what we say. And that's okay, as long as you don't personalize it. If you start saying, well, Lainey this or Andy that, or, you know, that girl you have on there, this, we delete them right away. And the second rule is you can't slander other people. You just can't say, well, so-and-so did this or so-and-so said that, or, you know, I'm being persecuted by somebody else. We can't have that. That's called slander. But other than that, we really welcome all your comments. I've actually gotten some good ideas for future episodes from some of the things that some of you say. So please continue to like, subscribe, and share with your friends. And I hope that you have a great day. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. Yeah, and that's that.
And that's that.
I don't know why I don't have any energy after any of that. Watching that hearing took a lot took a lot of energy out of me because I was all excited to go. Finally, one of these hearings was going to be in prime time, and I was going to be able to watch it because usually they come during the day and I'm working, and I like to watch them. I just have this curiosity. I got to watch them. And so this was going to be 4:00 Pacific time, but 7:00 Eastern time. So I was going to be able to go home, have dinner, walk the dog, make some popcorn, sit down. But oh my gosh, I fell asleep.
It's probably how they sucked all the energy out of those dead horses. It's probably how they killed them.
Oh, here with the horses again. Oh my god. Oh my gosh.
Just some boring content on for them.
It just went on and on and on and on and on and on, and then it went on some more, and it's just like, oh my gosh. I wanted to go in there with my own gavel. I mean, we have a gavel. It's right behind you over your left shoulder, right shoulder. No, that's all right. I wanted to get my own gavel and go over there. Come on, let's move this hearing along because I mean, often I've gone in on okay, fine. I've never been on a big quadruple homicide case. Granted, I'll give you that. But generally, I find when I go to court, I find the judges have read the pleadings, or their paralegal or court clerk has read it and briefed them and give them a summary sheet. So you go in there, they ask you a few questions, and it's like, all right, step down, counselor, next case. And that's what I wanted to have happen here. Step down, counsel, next case. But no, it just was the case that kept going and going and going and going. And I know, there's been a lot said about it, and different people have gone through different angles on the case, but I just saw it as an affront to the non-dissemination order. And I just saw it as just a continuation of just pushing it out and pushing it out and pushing it out. And I wanted to crawl into a tunnel.
It's good content. How some people listen to ASMR to go to sleep. We can listen to some Brian Kohberger case and go to sleep.
I always said if you have insomnia, just read a law book, read a contracts book, read about the UCC, the Uniform Commercial Code. That'll put you right to sleep.
Any of the documents you've gone over.
Yeah. I mean, it just goes on and on and on and on and on. All right, no horses this week.
No horses. Stay tuned.